In the previous section, we examined the legal and procedural requirements for providing title insurance in Arizona. That discussion emphasized the licensing, regulatory oversight, and due diligence required to issue a valid policy. Now that those foundations are established, we turn our attention to understanding the different types of title insurance policies available in Arizona real estate transactions and how each serves a distinct purpose in protecting the interests of various parties. While all title insurance policies share a common goal, to safeguard property rights and financial interests, they differ in terms of who they protect, the scope of coverage provided, and the duration of protection. The two primary categories are the owner's policy and the lender's policy. But within these, there are variations based on the level of coverage, property type, and underwriting standards established by the American Land Title Association, ALTA. The owner's policy, protecting the buyer's interest. The owner's policy of title insurance is designed to protect the buyer's ownership rights to the property. Once issued, it ensures that the new owner receives clear and marketable title, free from undisclosed liens, encumbrances, or ownership disputes. This policy typically remains in effect for as long as the insured or their heirs retain an interest in the property. For example, if a buyer in Tucson purchases a home and later discovers that a prior owner's relative claims an unrecorded interest in the property, the title insurer is obligated to defend the buyer's ownership rights in court and pay for covered losses. This protection is critical because title defects can arise years after a sale, often from events or mistakes that occurred long before the current transaction. Under ARS, paragraph 20, 1561 at SEQ, all title insurance policies must be based on a thorough title search and examination of public records. The owner's policy is typically issued after closing and recordation, when ownership is legally transferred. It covers losses arising from issues such as forged deeds, undisclosed heirs, recording errors, unpaid taxes or assessments, and defective conveyances. However, it excludes matters that the insurer disclosed before closing, known as exceptions to coverage, such as existing easements, restrictive covenants, or encroachments that were visible or previously known to the buyer. Arizona uses the ALTA Standard Owner's Policy or the ALTA Homeowner's Policy, depending on the type of transaction. The standard policy provides traditional protection against recorded defects, while the homeowner's policy offers expanded coverage, including certain unrecorded risks, such as post-policy forgeries, building permit violations, or neighbor encroachments. For residential buyers, the homeowner's policy offers more comprehensive protection for modern property ownership concerns. The lender's policy, protecting the mortgagee's interest. The lender's policy, also known as a loan policy, is issued to protect the lender's financial interest in the property. It ensures that the mortgage recorded by the lender holds a valid and enforceable first lien position on the property. This means that if a title defect arises, the lender's interest takes priority, and the insurer must compensate the lender for any financial loss up to the loan amount. For instance, if a lender finances a home in Gilbert and later discovers that a prior lien holder's mortgage was improperly released, creating a competing claim, the lender's title insurance will cover the loss or resolve the dispute. This policy remains in effect until the loan is paid in full or refinanced. The lender, therefore, maintains continuous protection against past title defects that could jeopardize their secured interest. Lenders typically require borrowers to purchase a lender's policy as a condition of financing, ensuring that the property serves as valid collateral for the mortgage. Unlike the owner's policy, the lender's policy does not protect the buyer's equity. It is solely for the benefit of the mortgage holder. Additional policy types and endorsements. Beyond the standard owner's and lender's policies, title insurers in Arizona issue specialized policies and endorsements to meet specific transactional needs. For example, a leasehold policy protects the interest of a tenant who holds a long-term lease, while an owner's extended coverage policy, OEC, may be used in commercial or vacant land transactions to provide expanded protection against unrecorded risks, survey issues, or zoning violations. Title insurance policies can also be customized through endorsements, which modify or expand coverage to address unique circumstances. Common endorsements in Arizona include Alta 9 endorsement, restrictions, encroachments, and minerals. Provides coverage for losses resulting from violations of covenants, conditions, and restrictions or encroachments not discovered during the title search. Access endorsement ensures that the property has legal access to a public road. Subdivision endorsement confirms compliance with local subdivision laws and ordinances. These endorsements reflect the adaptability of title insurance, allowing policies to meet the diverse needs of residential, commercial, and investment properties while maintaining compliance with DeFi regulations. Comparing coverage levels. The difference between the owner's and lender's policies extends to the nature and duration of their coverage. The owner's policy protects against losses for as long as the insured owns the property, while the lender's policy terminates once the mortgage is satisfied. The owner's policy covers the buyer's equity and title rights, while the lender's policy covers only the outstanding loan balance. Both policies, however, work together to provide comprehensive protection for all parties involved in a financed real estate transaction. For example, in a typical Arizona residential closing, both an owner's and a lender's policy are issued simultaneously if the buyer used a loan to purchase the property. The seller often pays for the owner's policy, while the buyer or lender pays for the lender's policy. This allocation is standard under the Arizona Association of Realtors residential resale purchase contract, though the parties may negotiate otherwise. Judicial and regulatory support. Arizona courts have recognized the importance of distinguishing between policy types and upholding their respective protections. In First American Title Insurance Cawas v. Action Acquisitions, LLC, 2008, the Arizona Supreme Court clarified that title insurance is a contract of indemnity, not a guarantee of title quality. The court held that title insurers are liable only for actual losses covered by the policy, reinforcing that the scope of coverage depends on the specific terms and conditions of the policy issued. This case, along with Burcons v. Ticor Title Insurance Causer of California, 1991, underscores the principle that title insurance is both a legal and financial safety net, one that requires careful examination of the policy's language, exclusions, and endorsements to understand the protection it provides. Burcons v. Ticor Title Insurance Co. of California, 1991, is a seminal Arizona Supreme Court case defining the fiduciary duties of escrow agents. In the case, Ticor Title acted as the escrow agent in a real estate transaction where the buyer obtained a loan secured by the property, but the escrow instructions were structured in a way that effectively subordinated the seller's deed of trust, without clearly disclosing that risk to the seller. When the transaction failed and the seller suffered losses, the seller sued the escrow company. The court held that escrow agents owe fiduciary duties of strict compliance with escrow instructions, honesty, and full disclosure of known facts that would defeat the purpose of the escrow. Even though escrow agents are not general advisors, they must disclose material information when they know the transaction structure creates an undisclosed risk. The case is frequently cited for the rule that escrow agents may be liable for breach of fiduciary duty when they blindly follow instructions that they know, or should know, will harm a party to the escrow. Discussion. Why do most Arizona real estate transactions include both an owner's and a lender's policy? Answer. Because each party's interest must be protected. The owner's policy safeguards the buyer's ownership rights, while the lender's policy secures the lender's financial interest in the property. What is the difference between the Alta Standard Owner's Policy and the Alta Homeowner's Policy? Answer. The standard policy covers recorded defects, while the homeowner's policy expands coverage to include certain unrecorded risks, such as forgeries or encroachments. When does a lender's policy terminate? Answer. The lender's policy remains in effect until the loan is repaid, refinanced, or otherwise satisfied. Review summary. Understanding the different types of title insurance policies is essential for real estate professionals and consumers alike. Arizona law requires that both owners' and lenders' policies be based on thorough title examinations and issued in accordance with DIFI regulations. The owner's policy protects the buyer's equity and ownership rights, while the lender's policy safeguards the lender's mortgage interest. Variations such as homeowners, leasehold, and extended coverage policies, along with endorsements, allow for tailored protection suited to the property type and transaction. Court rulings like First American Title versus Action Acquisitions reaffirm that title insurance is a contract of indemnity, ensuring compensation for covered losses rather than guaranteeing title perfection. Together, these policies reinforce confidence in Arizona's property transfer system, ensuring that ownership rights remain secure long after the transaction closes.